Good afternoon, ladies and gentlemen. Once again, James DePelisi with the Broward County Crime Commission. We're so excited about our upcoming webinar on September 30th, Wednesday, discussing our fourth annual Societal Violence Conference. There will be 3.5 CEU hours for most industries and modalities. Make sure that you go to www.browardcrime.org to register or dial 754-423-1976. It is my proud pleasure at this particular point in time to welcome Mr. Massad Ayoob from Massad Ayoob Consulting. A very, very accomplished person for quite some time, close to 50 years of experience in law enforcement and firearms, as well as legislation associated with Stand Your Ground. Welcome to the show, Mas. How are you today?
Doing well, James. Hope you and your friends are too.
Likewise, thank you. So tell us a little bit about yourself, your background. You're quite an accomplished person. We're so privileged to have you on this panel next Wednesday. Can you give our audience somewhat of an overview about your background, please?
Certainly. I've been teaching judicious use of deadly force to police since 1972 and to law-abiding private armed citizens since 1981. I've got about 20 books out there now, a couple of which critics have been kind enough to call authoritative texts on judicious use of deadly force. In the Gravest Extreme, published 1980 by Police Bookshelf, and Deadly Force, published by Digest Books in 2014. I teach use of force full-time through MassadAyoobGroup.com. I spent 19 years as chair of the Firearms and Deadly Force Training Committee for American Society of Law Enforcement Trainers, about 17 years now on the advisory board of International Law Enforcement Educators and Trainers Association, and many years on the board of trustees for Second Amendment Foundation. I've been an expert witness for the courts in deadly force cases and weapons cases going back to 1979.
That's very, very interesting and quite an array of background as well as credentials we will be able to share on Wednesday, September 30th. Once again, ladies and gentlemen, go to www.browardcrime.org. Mas, why do you feel the panel that you're participating in or in which you're participating, the emotions and legalities of Stand Your Ground and self-defense, why is that so important in 2020 right now?
Well, the legalities are reasonably well understood and well established. The public perception, unfortunately, is not. If you look back over history, since we became a nation, we followed English common law. Now, embedded in that was the principle of homicide se defendendo. You had the right to defend yourself up to and including deadly force if it became necessary. But under the homicide se defendendo principle, one was expected to avoid, if at all possible. And that included to flee the scene if one could do so, rather than engaging and fighting back against one's assailant. In American law, there are some states that have never required that. And going back to the United States Supreme Court decision in 1895 in Beard versus United States, it was made expressly clear that if the citizen did not provoke the encounter and is someplace where they had a right to be when they were attacked with lethal force, they need not attempt to retreat, and they may stand their ground and fight with an appropriate equal level of force. Some states have nonetheless instituted retreat requirements. And when this really became an issue in modern times, let's flash back from 1895, Beard versus United States, affirmed in 1921 in Brown versus United States, the case where Oliver Wendell Holmes wrote famously in the majority opinion, detached reflection is not demanded in the presence of an uplifted knife. Now, flash forward to about halfway through the first decade in the 21st century. Some states had a stand your ground requirement, some states had a retreat requirement. The state of Florida had emphatically had a retreat requirement. And in a package of legislation that was passed, which I feel in every respect greatly benefited justice in general and the law-abiding armed citizen in particular, the retreat requirement was rescinded. Now, about 4 elements were going on in that legislative package. First, the one from which it drew its name, the retreat requirement was rescinded. If you were somewhere where you had the right to be, had not provoked the encounter, you could stand your ground and use deadly force if necessary to defend yourself or others you had a right to protect. You'll find that in Florida Statute 776.012. 776.013 reestablished and clarified castle doctrine, another element of English common law that we've always had in every state, whether in black letter law or in case law or in jury instructions, that said if you're attacked by an intruder within the confines of your home, or in the Florida statute, the current one, in an occupied motor vehicle, you did not have to go back to the wall. You had the right to fight and protect your castle, if you will. The principle being every citizen's home is their castle, and attack there, they need not retreat.
Right.
Finally, 2 other elements are addressed in 776.013, or excuse me, .032. There was an element established for a hearing prior to trial in which a judge could determine to a preponderance of evidence that it was self-defense. And at that point, the thing was dead. And that grew from so many cases where politically motivated prosecution wound up still resulting often in an acquittal, but at the expense of a terrible cost to the public purse, probably more terrible cost to the individual, often bankrupting them in legal fees. And finally, the terrible emotional cost of the wrongful accusation. Now, tied in with that was an element of tort reform that if the shooting or the use of force had been determined to be self-defense, that would allow a judge to immediately throw out any lawsuit arising from the incident. Now, the trick there, of course, was qui determinat, who determines. And the way it worked out, if what became known as a stand your ground hearing, even though stand your ground was not an element, if that had come out in the defendant's favor, that would suffice. Or a memorandum of closure by the prosecutor's office explicitly stating that either we've investigated this incident and found it to be self-defense, or we've investigated this incident and ruled it a justifiable homicide. That 4th element now is sort of off the table since a 2017 decision by the Florida State Supreme Court. So that one's sort of in abeyance. But what you had at the time were 4 separate legal concepts in one package. And of course, you could only give the package one name, so stand your ground covered all of them. This left a whole lot of people confused as to what does stand your ground have to do with killing an unmeritorious lawsuit? What does it have to do with killing an unmeritorious prosecution, even if a retreat element was not part of the case? So we've seen many misinterpretations. We've seen firearms prohibitionists claim that the so-called stand your ground law says you can kill anyone and get away with it if you just say you were in fear. And of course, that's far, far from the case.
Well, that's true. I appreciate you adding balance to both sides of the equation there. There's so much to talk about on this topic, and we really look forward to having you next Wednesday, September 30th, ladies and gentlemen. Be sure to go register at www.browardcrime.org or dial 754-423-1976. Mas, thank you so much for joining us today, and we look forward to having you next week. Thank you.
I'm looking forward to it myself.
Great. Thank you.